The questions over the Prime Minister's approach to British veterans during his time as a senior barrister have escalated. Yesterday, when it was reported that Sir Keir had worked pro bono on a human rights case against British Iraq veterans, Number 10 responded by saying the Prime Minister did not represent the claimants in this case. He represented interveners, including the Law Society of England and Wales. The role of an intervener is to assist the court on points of law, not to advocate for either side. They also stressed that Sir Keir was not involved in the later European court rulings that expanded investigations into British troops. The Prime Minister was not involved in the subsequent case heard in the European Court of Human Rights. Sir Keir did not directly represent China's clients, but he did work on related cases and wrote publicly about the legal arguments. And today it's been revealed that in 2008, in a book on the Iraq War, which was edited by the much-disgraced Phil Shiner, Sir Keir wrote that the European Convention on Human Rights Law was far more effective than United Nations law. He said that the way international law had developed suggested, quote, a deliberate effort by the USA and the UK to change international law for their own ends. And he also wrote that multinational forces operating under UN authority were usually immune from legal processes, and argued that European human rights law was much better developed and far more effective in holding governments to account. Thus, he collaborated in a book by Shiner that works to undermine the position of the British government. Today's revelations, following Number 10's firm denials, raise more questions than they answer. Number 10's statement focuses on technical distinctions, intervener versus claimant, rather than what Sir Keir may have been arguing for and what he appeared to believe at the time. Some senior human rights lawyers are saying that describing this role as neutral is misleading anyway. Interveners are invited to advance legal arguments and that they are not detached observers. So the issue is no longer whether Sir Keir was technically entitled to do this work. The issue is what it says about the Prime Minister's judgment and alignment, whether the Prime Minister's insistence of neutrality matches his words, actions and involvements. It is not the normal defence of lawyers, which is the cab rank defence, that lawyers must take any client, because that rule naturally and obviously does not apply to pro bono, that is to say voluntary work. So by issuing an aggressive and categorical denial, Number 10 has shifted the focus. This is no longer about Sir Keir's historic work. It's about credibility, consistency, and whether the Prime Minister's account can be trusted, especially given his responsibility as Prime Minister for the well-being of the armed forces. The denials have raised more questions, not shut them down, and these questions will continue to come until the Prime Minister is more transparent.